Good afternoon. My name is Andy Pugno, General Counsel for the proponents. I'm introducing today three folks I have up here. First of all, Ron Prentice. He is the chairman of the ProtectMarriage.com coalition. Austin Nimocks from the Alliance Defense Fund, our co-counsel. And to make our statement, our lead counsel, Mr. Charles Cooper.
Good afternoon, ladies and gentlemen. We are very pleased to be in this courthouse today to present our arguments to the Court of Appeals in defense of the constitutionality of Proposition 8, in defense of the judgment made by the majority of the voters of the state of California. I want to pay our respects to our opponents in this case, who have presented their case with skill and with sincerity, and we respect that. I regret, in all candor, that our opponents do not return that respect to the arguments and the positions that those of us defending the constitutionality of Proposition 8 have advanced, but rather have seen fit to demean and to ridicule those arguments. We believe that even more troubling is the essential point made with respect to the well over 7 million people in this state who supported traditional marriage and the enactment of Proposition 8. We believe that people of goodwill can disagree in good faith on this question, and that there are good and decent people on both sides of this debate. People from all walks of life, from all political persuasions, from all races and creeds, simply acting according to what they believe is best for their community, their state, and themselves. Our opponents don't agree with that. They believe that everybody on the other side of them in this debate is behaving irrationally. That no defense, no good faith belief can be entertained in defense of the institution of marriage, which has existed, as we pointed out in the court earlier today, in every place and at every time in recorded history. The place for this question to be decided is the place where it was decided, by the electorate through the democratic process. Now, in the court hearing just now, there was obviously time for the court and for the advocates to touch on only a fraction of the issues that have been raised. As I'm sure you know, there's several hundred pages of briefing in this case, and it's not the appropriate forum here to attempt to re-argue that case, but I do commend you to the full briefing for a complete discussion of all the merits of the case by all the parties. For the plaintiffs to prevail in this case, they have to show not only that all of the state and federal appellate courts that have addressed this issue, all of whom, by the way, have upheld traditional marriage laws and rejected the same arguments essentially that have been advanced here today, that all of those judges rendering those decisions were irrational. That the Congress that enacted the DOMA, that all of those people were irrational. that a large majority of the population of this country is irrational and behaving not in good faith. That President Obama, for that matter, must presumably be irrational. That is not, that position we believe, with all due respect to our opponents, is not sustainable and is not valid. In conclusion, if marriage is to be redefined in this state, it is the people who should make that decision. Now I'd like to turn the podium over to Mr. Nimocks. Thank you.
Thank you, Chuck. Again, my name is Austin Nimocks, last name N-I-M, as in Mike, O-C-K-S. My title is Senior Legal Counsel with the Alliance Defense Fund. On behalf of the Alliance Defense Fund, it has been our privilege to stand with the attorneys at Cooper and Kirk and the ProtectMarriage.com team in defending Proposition 8 in this case. On November 4, 2008, nearly 14 million Californians participated in that most American and democratic of exercises, a vote. The vote was the pinnacle of months and tens of millions of dollars of campaigning, where all Californians were able to hear the arguments on both sides, understand what was at stake and what was being articulated, and cast, in accordance with the traditions of this country, the decision that they believed was in the best interest of California, society, and themselves. This decision by the California voters made it the 30th state to enact such a provision, placing the importance of marriage in the text of its constitution. Of the 30 states that have presented their citizens with the option of voting on this question, all 30 of them have acted identically to California, placing the importance of marriage as the union of one man and one woman within the text of their constitutions. These collective votes span from coast to coast, north to south, red states and blue states, but yet are all unified in one simple fact, that marriage is the union of one man and one woman. This decision by Americans, tens of millions across this country, is rational. As Mr. Cooper and our legal team have articulated in this case, these votes are aligned with the definition of marriage enacted by Congress, proliferated by President Obama, upheld by the Supreme Court of the United States as constitutional on more than one occasion, as well as the decision of every other federal appellate court to address this issue, and of course, history. I will now be happy to answer any questions. Yes.
What was it like having these proceedings today televised? Obviously, that was the rules here, the circumstances are different, but it's not something we haven't had a chance to talk too much about since the beginning of the year at the trial. Can you talk about how much that affected your presentation? Whether you had any concerns about that?
We can't say that the legal arguments here and the constitutionality and the questions of constitutional importance changed by having it televised. It was within the provisions of the court rules. Yes, sir.
The other side had a mantra earlier today that you weren't harmed. What can you tell us about whether you were harmed?
Well, that really doesn't affect the constitutional question is not whether people are harmed, but whether people made a rational decision. Mr. Cooper went extensively into that during the course of the oral argument, and I cannot improve upon what he answered to the court in response to questions along those lines.
Mr. Cooper had said that he was disappointed with your opponent's meaning and feeling of the stand, was how he phrased that. Do you believe that the people you were representing are victims somehow in not only this case, but the larger arena of gay marriage?
I think the citizens of California are victims in a great way when those who are elected to uphold certain duties, for example, like the Attorney General, fail to perform the duties and defend the law that they've enacted. And so, we're here proudly representing Californians in the duly and the vote that they duly made. But all Californians are victims when their elected officials fail to uphold their oath to uphold and defend the laws and Constitution of the state of California.
Californians were later to vote to give marriage rights to same-sex couples. Would you honor their decision to do so?
Well, I think the California people are sovereign, and they have the right to make public policy decisions like they did in Proposition 8, and that is the fundamental essence of our contention in this case. So we believe that they were sovereign to make the vote that they did, and that it was rational as a matter of constitutional law.
There was a lot of talk about the significance of removing a right. Talk a little bit about that and the weight that it has in the argument that you're making in Proposition 8.
Well, as Mr. Cooper clearly articulated during the course of the argument, citizens have the right to make public policy decisions and to make policy decisions that are one way one particular year and another way another particular year. As a matter of constitutional law, the people, as the sovereign governors of this state, have the right to make that decision, and so it's clearly within the people's sovereign power. That's the best the answer that I can give to that question.
Are you arguing that you have no opinion on whether it's the right thing to do or not, just that once the people speak, that's it?
As a matter of constitutional law, the people must have a rational basis for the decisions they enact. And the court, as you heard, went into the questions of whether or not a basis can be articulated that is rational, that supports the people's decision. In the over 200 pages of briefing that we filed with the court, we have articulated multiple rational bases, and so that is really the end of the constitutional query. That is our position.
Rational has nothing to do with the ethics of it, whether you believe it's right.
No, the question before the court is one of constitutional law, and whether somebody believes that something is the right thing to do does not affect what this court is doing under the U.S. Constitution.
How confident are you after the questioning today that you will be given standing to bring this case forward?
We feel very confident about standing. We have from the outset, and our participation in the court below, we believe that we do have standing. We have the winning argument as articulated very well today by Mr. Cooper, and so if we don't, it'll be, I think, another tragic day for California, because then again, a measure which was enacted by over 7 million Californians will have gone down with nobody standing up to defend that measure whatsoever.
Well, can you appeal that decision? Can you appeal that decision? Standing, can you appeal that?
Can we,
If standing doesn't against you, can you appeal it?
that'll depend on, well, there's obviously two standing questions with regard to the proponents and the Imperial County, but yes, the answer is yes.
Did you feel like the judges were leery about ruling that you don't have standing, and that somehow would confer on the governor or the attorney general a veto power of propositions that they currently do not have?
I learned a long time ago not to try to read the poker faces of judges. I think somebody earlier said that they do have a duty to probe all the issues, and I concur with that statement. You can never know where a judge's mind is going based on the nature of the questions they're asking. They were obviously prepared and exploring all the angles.
I guess a better way to phrase my question is, what was your reaction when you heard that line of questioning coming from the judges today?
I wasn't one bit surprised. I expected that line of questioning. And I, as you can tell from Mr. Cooper's responses, he expected it more than I did. Yes, sir.
I just want to
One more.
get your reaction to something that David Boyd said just a moment ago. He said 20 or 30 years from now, people will look at this case and wonder why it was necessary. People will look back, and at the way we look back at Brown versus Board of Ed, and ask why it took so long. Just wondering what your reaction is.
That's a great thing about America. Everybody is free to disagree. And the over 7 million Californians that voted on this measure have a different opinion about that, and that freedom to disagree is the real crux of what this country is all about. Thank you very much.